Respected seniors and friends, good evening. It's been an honor and a pleasure to welcome Shri Atmaram Nadkarni, Senior Advocate and Additional Solicitor General of India and the Supreme Court. Nadkarni sir is one among the most firebrand lawyers who hails from Goa. He started his practice in Goa, and at the young age of 36 years, he became the Advocate General and has served in the said position for the longest point in time before shifting to Delhi in the year 2016, after which he was appointed as the Additional Solicitor General, and he has appeared in very many important and sensational matters. He is known for his firebrand advocacy, and apart from his deep acumen in law, in fact, I must personally thank Atmaram sir for accepting our invite in a very short notice and agreed to speak on a very sensational, relevant, and contemporary topic that all of us are discussing today. The concept of free speech, which is embedded in our Constitution in 19(1)(a), is a matter that has always been a subject of debate since 1950, and especially in the present era, where the traditional print and electronic media stands superseded by social media like Twitter, WhatsApp, Facebook, and Instagram. Hashtags, retweets, and forwards have become the universal norm. So in these areas, free speech certainly has to strike a balance with the interests of the community, public order, and there are so many interesting issues in today's lecture that the speaker will highlight to us, and it will certainly be a food for thought. Without any ado, I welcome Atmaram sir once again and leave the floor to him. Sir, floor is up to you, sir. Thank you very much for accepting the invite.
Thank you, Naveen. Thank you so much.
Yes.
Friends, good evening. As regards the freedom of speech, before we get into the topic, there is an old saying, and in India it is very much reiterated at times by the elderlies, that after being born, within a year or two, we learn to speak. But the problem is what to speak, where to speak, what not to speak, when not to speak, and where to remain silent. We take a whole lifetime to learn this thing, which is otherwise a basic thing. At times, silence is golden. Coming back to the topic, the freedom of speech is regarded as the first condition of liberty. It occupies a preferred and important position in the hierarchy of the liberty. And it is truly said about the freedom of speech that it is like the mother of all liberties. Freedom of speech and expression literally means the right to express one's own convictions, one's own opinions freely by words of mouth, writing, printing, pictures, or any other mode. In modern times, it is widely accepted that the right to freedom of speech is the essence of our free society. And given this importance, it is imperative that it must be safeguarded at all times. The first principle of a free society, which is civilized in its nature, is obviously an untrammeled flow of words in an open forum. Liberty to express opinions and ideas without hindrance, without any dictation, without control, and especially without fear of being prosecuted or punished, plays a very significant role in the development of our particular society and ultimately for the state or the nation, as the case may be. It is one of the most important fundamental liberties guaranteed against state suppression or regulation. Freedom of speech is guaranteed not only by the Constitution of India, but literally by various constitutions of the world. Several international conventions like the Universal Declaration of Human Rights, European Convention on Human Rights and Fundamental Freedoms, International Convention on Civil and Political Rights. These declarations expressly talk about freedom of speech and expression. Now, why is there a need to protect this freedom of speech? The freedom of speech offers to human beings and rather gives a vent to express their feelings to others. But this is not the only reason. The purpose to protect the freedom of speech is there are several reasons, and one of the most important thing is that it constitutes an essential of the liberty. Liberty, as John Stuart Mill said, is the absence of arbitrary restraints. One of the reasons could be the truth can be discovered only by open discussion. According to this principle, if the restrictions on speech are tolerated, then the society is prevented from ascertaining and publishing the accurate facts, as also the valuable opinion. And therefore, the freedom of speech itself assists in the discovery of truth. The other thing is, free speech is a part of an aspect of self-fulfillment, self-development. If you want to develop your personality, freedom of speech is an integral aspect of one's individual right to self-development and self-fulfillment. Restriction on what we are allowed to say or write or hear and read will definitely hamper the personality and ultimately the growth of the individual. So therefore, in the process of attaining self-fulfillment, all these things are important. The third important thing is, for expressing your beliefs and political attitudes, the freedom of speech gives you an opportunity to express your beliefs, to show your political attitudes, and all this is supposed to ultimately result in the welfare of the society and the state. The freedom of speech, in other words, in short, is a mechanism by which it is possible to establish a reasonable balance between stability and social change. In a democracy like ours, and that too in a vibrant democracy like ours, most important feature today is the right of the citizens to understand political issues so that they can themselves participate in the working of their democracy. In other words, the freedom of speech strengthens the capacity of an individual in participating in decision-making process. Ladies and gentlemen, this was regarding the freedom of speech and the importance of that particular freedom of speech. Today's situation presents an altogether different scenario. In the 19th and the 20th century, and vis-a-vis our march toward the 21st century, from an industrial age, we have progressed to an information age. And in this information age, you have what is called as Facebook, you have Twitter, you have retweeting, you have hashtags, you have Instagram, you have several such facilities on the net and internet whereby you can disseminate information, you can put out your views, and you can create so many things. In fact, the potential of disseminating the information is so wide and also important that you can do so many things, media and platforms. A problem came Today, for example, there is Facebook, there is Twitter, there are so many other things on the net, YouTube, etc. We have a freedom of speech, and the freedom of speech can be controlled by the state. Article 19(1)(a) deals with, in part 3 of our constitution, envisages that freedom of speech. But it of course says certain reasonable restrictions can be put by the state. I am not for the present going into the power of the state to impose reasonable restrictions. For this purpose, we shall proceed on an assumption that the state has a right to, in certain cases, curtail the freedom of speech. But my topic for this webinar, I am taking a slightly divergent view. That is, suppose I put out a defamatory material on the Facebook, or say Twitter, or retweet something which causes defamation of someone. Defamation is just one of the illustrations that I'm giving and picking it up. Suppose I put out something obscene. I put out some statements which are seditious, which are anti-national. The question is, the platform provided to me is by Facebook or Twitter. And I am the one putting out a defamatory material or an objectionable material. If prosecution has to be launched, then the Facebook, Twitter, or Instagram, they will also be liable like me. It's like on a newspaper. You publish a defamatory material. Maybe Mr. X has said this, but along with that, the editor of the newspaper itself will be charged for defamation. Because they have made it, they have published it. The question here is, I'm aware of the background of 66A of the Information Technology Act, which had been partly struck down also. We'll come to that a little later. Question is, can Facebook or Twitter or Instagram control your right to speak? I hope I've made myself clear. It's a little complicated question because it raises yet another variant of a vexed question. We have already said that for the purpose of our debate today, we proceed on an assumption that state has the right to control the speech, impose reasonable restrictions. Now comes the second part, that I'm using the platform given by Twitter or Facebook. Is it possible for Twitter and Facebook and Instagram to control my speech? Leave out the defamatory portion, leave out the offending portion. And if they do so, would they be interfering with my right of free speech? This is just one question that I'm posing, and it assumes importance because many of you would be aware of the Cambridge Analytica data breach, which occurred in the early 2018 involving Facebook. I may just recapitulate it for readily reckoning it. The Facebook and Cambridge Analytica breach occurred in early 2018 when millions of Facebook users' personal data was harvested without consent by Cambridge Analytica to be predominantly used for political advertising. Mind you, this data breach was the largest known leak in the Facebook history. The data was collected through an app which was created by Alexander Kogan, a Cambridge academic, in 2013, and it consisted of a series of questions to build psychological profiles on various users. The app not only harvested the personal data of the users that completed the questions, but also of the users of the Facebook and their friends. Cambridge Analytica sought to sell the data of American voters to political campaigns. And it ultimately provided assistance and analytics to the Ted Cruz and Donald Trump campaigns. This is all well known, it's in the public domain. The data breach was disclosed in 2018 by a former Cambridge Analytica employee, Christopher Wiley, in an interview with The Guardian and New York Times. In response, the Facebook apologized for their role in the data harvesting, and their CEO, Mark Zuckerberg, testified in front of Congress. This happening sparked an online movement against the Facebook, saying, delete the Facebook. And this delete the Facebook went trending on the Twitter. The freedom of expression recognized as a human right under Article 19 of the Universal Declaration of Human Rights, under Article 19(1)(a) of the Indian Constitution, it is recognized in terms of the International Human Rights Law and including in the International Covenant on Civil and Political Rights. The essence of this freedom of speech is you should have the ability to think and speak freely and to obtain information from others. This essence to think freely, express yourself freely, open up and obtain information from others, whether through publication, public discourses, and all this without fear, anxiety, retribution, any restriction or repression by the government. So it is through such free speech that people come together to achieve a political influence, to strengthen their morality compass, and to help others become moral and enlightened citizens. And in fact, Mr. Dhirijendra Patanjali had written about it. I cannot often quote him what he had written, but he had nicely expressed some of his views. Now, the basic thing is, to what extent is this freedom of speech permissible? Basically, what is the liability of the Twitter? What is the liability of the Facebook? What is the intermediary liability in holding such a social networking website? Are they liable for the offense which is committed by its users? Obviously, the answer would be in the affirmative, because you having created a platform, the reasons for holding an intermediary liable would be numerous. Firstly, by the sole reason of having created the platform through which the users are committing this offense. Secondly, it is very difficult to catch a wrongdoer, especially if they are using some different IP addresses, at times even fake names, and they are using the social media anonymously. Thirdly, such content which is defamatory ought not to have been allowed on the media. It is not allowed on other media, and therefore social media networking websites cannot be an exception to it. The social networking websites, they profit greatly from the posting of such scandalous content on their websites. For example, when a user posts something on the Twitter, thousands of users can retweet at the same time, and that particular defamatory post spreads like a wildfire. Now this, what you can achieve on the Twitter, you cannot achieve it through any other media apart from such social networking websites. Maybe you can do it on the Facebook or Instagram, etc. Other media do not allow users to simultaneously voice their opinions and express themselves in any way as they deem fit, like it is allowed here. Another reason, keeping the earlier reasons in mind, to further their profit, the intermediary may also deliberately keep the defamatory post continuously in the public domain, in the public views. For example, Facebook may have certain mechanism by which they can keep showing the most shared, most commented post on your homepage repeatedly. Such an act directly makes the intermediary liable for defamation on social media. Again, there are various technicalities that come into question here. What if such mechanisms are automated and are not manual? Whether in that case would they be liable? Logically it should, since the algorithms that compute which post to spread is fed into the system by the intermediary itself. And it is they who want the system to function in a particular manner. Therefore, this would again make the intermediary liable. Now, considering all these reasons, the intermediary becomes liable. Therefore, the cons of having the intermediary liability indicates that a private body will be liable. Now we come to the second variant of this vexed question, namely, once we come to the conclusion that the intermediary is liable, then this intermediary, which is a private body, will it have the right to control and censor all of the data that you have posted on its site, which could lead to violation and oppression of a user's freedom of speech and expression? I hope I made myself clear. We have seen that the intermediary becomes liable, and once the intermediary becomes liable, obviously the intermediary or the Twitter management would say, look, don't post such defamatory or offending articles on my platform. The moment you post it, I will have the right to censor it, to delete it, or to take it away. So now we have the state which could impose reasonable restrictions. And now apart from the state, we have the private body which is otherwise not competent in terms of the constitutional provisions, because 19(1)(a) says only the state can impose reasonable restrictions. But here is a private body, the intermediary, which may become, maybe by way of becoming overcautious or for their own safety, or they think it wiser as a safety measure to avoid any prosecution, they may start screening all of your data and blocking even the remotely inflammatory material. Surely, this will have a chilling effect on the user's right of freedom of speech and expression. And hence, whether this will affect adversely the utilization or the expression of the constitutional right which we have in the nature of a fundamental right. Now, protecting one man's right to privacy and reputation, the entirety of the users and the user's right of freedom of speech and expression will be hampered. Keeping in mind the cons of having intermediary liability, what would be the alternative? Should Facebook, Twitter, Instagram, or any such platform owners be given the right to screen, analyze, censor, control your data or what you have posted. Should they be or not? It is not an easy task to single out every user who wrote a defamatory post on social media, especially if there is a mass defamation, as is commonly seen on social networking websites. Most social networking websites have millions of users. And even if out of those millions, a few thousand share the same post, defaming the same person or organization, it would mean that the concerned person or organization would have to hunt down each of those 1,000 people and then file cases against them. It could be not just people, it could be places, and it could be so many other things also. It could be defaming certain organizations also. And it is in this context that the question which is of paramount importance is basic nature of intermediary liability, the various laws on such intermediary liability abroad and in India, especially in the United States of America, the European Union, and in India. In India, for that matter, we have the Information Technology Act. The Information Technology Act of the year 2000, it governs the laws on intermediary liability. This law, though of the year 2000, and we are in the year 2020, I must say that this is fairly a new concept, which is still gaining its ground insofar as our country is concerned. There has not been much case law supplementing this particular act, but the 2011 rules, the IT intermediary guideline rules, in fact, have supplemented to a great extent the main law itself. For the purpose of our debate, a social networking website under the Information Technology Act of 2000 is indeed an intermediary. Please have a look at section 679. It's an important section as regards intermediary liability, which provides for certain cases in which an intermediary would not be liable. I can give you the 3 instances which have been listed there. The intermediary's function is only to provide access to the system, which means it does nothing else other than providing access, platform for users to post their content. The intermediary does not start to choose a user on its own or even the information, and does not even modify the information. Again, this means that it does not monitor any content being put on the website. They are a mere host. And the intermediary observes due diligence and abides by the guidelines posted by the government. The only exception which is carved out is under the Copyright Act and the Patents Act. In case of a user of a social networking website, if you infringe someone's copyright or patent, then there is nothing stopping the owner of the copyright or patent to pursue the action against that particular user and not the intermediary itself. The Copyright Act by itself also provides that if the intermediary responsible for such storage has received a written complaint from the owner of the copyright of the work, alleging that such storage is an infringement of the work, the intermediary should stop facilitating access for the work for a period of 21 days until it receives an order from the competent court regarding the matter. Thus, even in copyright matters, the intermediary may be held liable. What is interesting is, and it's required to be noticed, that they have a notice and takedown liability. That means when a user formally complains about any other user posting a defamatory matter or offending matter, and the intermediary still does not remove the content despite notices, the intermediary shall be held liable. And if it is considered to be the duty of the intermediary to take down a post once it receives a notice against that particular post, and if it does not do it, then obviously it is liable. But this can give rise to various set of other questions. Namely, the intermediary may remove only one particular post of which the complaint is lodged, but there may be other posts similar to it. What should the intermediary do? Remove all other posts or remove the post which is complained of? So, by taking down someone's post on one mere notice, the intermediary is to a great extent affecting, if not violating, I'm making very clear, affecting, if not violating, the user's freedom of speech and expression. Delhi High Court had a case before it to decide. Super Cassette Industries and MySpace, wherein users on MySpace were sharing images and music over whom the copyright was owned by Super Cassette Industries. Many of you must be aware of it. Although MySpace argued that it was merely an intermediary within the ambit of Section 79 of the Act, the Delhi High Court did not accept the contention. It said that Section 81 of the Act would have to be read along with Section 79 and given precedence since it is an issue of copyright law. I believe the final judgment, I'm not sure whether it is delivered now, but it is apparent that the courts do not seem to be lax on the intermediaries just because of the safe harbor provision. Section 79 is that safe harbor provision which provides a safety net for the intermediaries who act merely as conduits. In Section 79 also, it's a conditional safe harbor which provides a safety net for intermediaries, but only in particular cases. That is, if they satisfy the requirement of that section. There have been many criticisms on this, that the Act is not very clear in its application. The lack of case law on the subject does not hold further its cause. For example, several things, several examples, this is not an occasion to sermonize all those objections, etc. But by and large, what is important is, though the Information Technology Act has come into force, it has given a recognition to a mode of communication and dissemination of information through the latest technology available. Yet, it is most unfortunate. In our country itself, we still do not use the Act or the electronic gadgets fully. For example, large number of witnesses are brought from place A to place Z. It's not required. A witness could be examined on video conferences. Number two, take another case. A will which is executed by the testator. Two witnesses are required. So they still bring conventionally the two witnesses, make the elderly person execute the will, and then the witnesses are brought to prove it. Why can't you make a video of the person while executing the will? He can talk and depose as regards the will then and there. Of course, the witnesses could still be there. And thereafter produce the very CD or disc in the court of law as a proof of it. I'll tell you what happens normally. When a will is executed, the party challenging the will invariably says that the testator was not in a position to understand what he was writing. He was not in a position to know what was happening. The testator was sick. He was in coma. All those kind of things. I mean, all this can be done away with if you use properly the provisions of the Act. Now, this we have seen about India. Let us for a moment come back to other parts of the world, since we are taking a view of Indian conditions and overseas. In the United States of America, you have something called as Communications Decency Act and the Digital Millennium Copyright Act. These are two main laws which deal with intermediary liability. I need not dwell much on that. The Digital Millennium Act deals with issues of copyright and not with as regards the content which is posted on the social networking websites. The Digital Millennium Act, like our Indian Information Technology Act, provides the conditional safe harbor approach and also provides for notice and takedown liability. The law is almost similar insofar as India is concerned. The difference in the case law is that specific instances in which the intermediary would be liable have been set out. For example, in Viacom versus YouTube, a dispute between Viacom and YouTube, where Viacom alleged that YouTube was responsible for, since its users were posting content on the website, which was infringing the copyright owned by Viacom. The court said three major things, and this is of some importance. A, one of the things which it said was that the Viacom was required to show that the intermediary, YouTube, was having specific knowledge of the infringement of the copyright. Two, although not necessarily in every case, intermediary would be definitely liable if it voluntarily has made any efforts to substantiate the already infringed copyright in any manner. And three, the burden of proof lies on the owner of the copyright to prove that the intermediary had specific knowledge of such infringement, but yet failed to do anything about it. And in this particular case, incidentally, YouTube wasn't held responsible since Viacom failed to discharge the burden of proof. However, what is of immense importance is this judgment of the court brought immense clarity to the act, which till today has not been done by the courts in India. And there should be sufficient clarity in the Act in order to interpret it rightly. The second legislation, the Communication Decency Act. Communication Decency Act, section 230 deals with the intermediary liability. It defines what is an intermediary liability, meaning the one which is providing interactive computer services. And though it gives it a broad immunity, it only specifies that the intermediary will not be liable if these providers are not considered as publishers of the content. In other words, they will not be liable for the defamatory article published by someone or their user. Not only this, it also states that the interactive computer service providers are not even liable to remove any content that it may be deemed to be offensive. And there has been a very interesting development regarding the Communication Decency Act in the US. There was a case that challenged the constitutionality of the entire act. The court struck down the entire act but section 230 and the definition of interactive computer service providers. It has been held to be constitutional, and the immunity provided to them continues to be available. Of course, you all know the recent presidential orders issued by which President Trump sought to take away the immunity which was conferred on them. That's another part of the debate. Those are subsequent developments which have taken place. But an important case under this, Doe versus MySpace, wherein MySpace was alleged to be liable since it allowed minors to enter their website without any stringent verification. This was said to be dangerous since the minors could come in contact with potentially dangerous sexual predators. But the US courts decided in favor of MySpace by holding that an interactive computer service provider could not be held liable for any content posted by a third party, that is its user. Ladies and gentlemen, we have seen the Information Technology Act, we have seen the Communication Decency Act, we have also seen the Digital Millennium Copyright Act. We have also seen the conditional safe harbor which has been provided and the sort of a complete immunity given by section 230 of the Communication Decency Act. Now we come back as the topic deals with hashtags and retweets. And it is important in this context, certain general aspects. See, it is very easy to say what we would like to say. As I've said right in the beginning of my lecture, the beginning of this webinar, that we learn to speak within a year or two of being born. But what to speak, when not to speak is all we take a lifetime for it. Of late, you must have come across various criticism. Normally, the criticism used to be against the government or against politicians or against certain individuals. Of late, even the Supreme Court of India has not been spared. I'm not saying that Supreme Court of India is beyond any pale of criticism or cannot be criticized. One has a right to speak. One has a right to voice his opinion. And if the circumstances so require and there is a need to speak out, person must speak out. There is no doubt about it. The question is, we are not in the normal times. We are going through very unusual, uncertain, precarious situation, virtually like tight corners. Who knew that this COVID-19 will come and it will affect the whole life? It has not affected India only. It has affected the world over. Maybe it is spread by some country or whatever it is. But everywhere there is a lockdown. In India, the peculiar situation is we, apart from the fact that our overpopulated country, the rate of illiteracy vis-a-vis literates, the rate of poor versus rich, haves and the have-nots, that gap exists. It is true that when the government declared a lockdown, it must have considered all these things. And I'm sure all these things must have been considered by the government. But lockdown was not a planned thing which was done. It had to be done all of a sudden. First, Delhi declared lockdown. Prime Minister declared that there would be voluntary lockdown of 1 day or 2 days, whatever it is. Thereafter, the lockdown started. And it was all done because the medical experts, various other experts advised that this lockdown is a must. That was done in other countries. I've also seen opinions expressed against the lockdown, saying that such lockdown is not required. Maybe one doesn't know. Each one of us will have our own opinion. But under our constitution, a government has been elected, and therefore the government is required to take a policy decision, and it is presumed that the policy decision taken by the government is obviously in greater public interest and for the welfare of the citizens. So once this lockdown was started, it is unfortunate that the migrant laborers started walking back to their home. The migrants are actually poor people. All that they need is sympathy, reassurance, and reaffirmation. They are virtually people who live from hand to mouth, who are daily earners, and if you don't earn daily, they do not have anything to feed themselves or the family at night or the next day. They are not those who have got a lot of savings or property, etc. So naturally, they were concerned about their homes, they wanted to migrate, etc. Government was doing its best. Every state government, union government, they were providing vehicles, they were providing this. Of course, the issue to a great extent got politicized to an unnatural extent. And everyone started jumping in the bandwagon. Matter went to Supreme Court. And in Supreme Court, one of the things that was observed is that these are basically executive matters of executive dominion. And therefore, the executive must look And the executive, since it is looking into it, there was no question for the judiciary interfering. Well, there have been criticisms about this approach, etc. There have been a lot of voices in support of this approach. It is not that you can have judges who are idle and who refuse to interfere in every matter. At the same time, activist jurisprudence is not something which is very much required in a democracy if it is taken to an unnatural extent. But there has to be a balance of both, and Supreme Court is the arbiter of the rights and wrongs done by an executive or the legislature in their field of functions. I'm not saying who is right, who is wrong, etc. I'm also not saying that people ought not to have criticized. You have a right to criticize, you have a freedom, but it is not that the Supreme Court was displaying some partial attitude to the government. Look at the recent order which has been passed. Fortunately, today we have a judgment from the Supreme Court where they have given directions after directions, taking care of all those migrants and those who want to go home, etc. When a government is seized of the matter, you will have to give some time to the government to perform. And it's only thereafter that the courts step in exercise of their constitutional jurisdictions. But in the meantime, if we go on making comments, if we go on making speeches or go on raising voices, it does create some kind of ripples. And in a democracy, vibrant democracy like ours, all this is not in very good taste. I'm not taking any sides. I'm not saying that you cannot criticize. I'm also not saying that, nothing should have been done, etc. I'm only saying that having regard to the times through which we are going through, before we express our opinions, we need to think. The opinions go in public domain, then there are counter opinions, then again opinions. By and large, the history has proved that our high courts and Supreme Courts have done a wonderful job in exercise of its powers under Article 32 and 226. The constitutional courts have secured liberty of people. They have set free people who are going illegal detention. Look at Bandhua Mukti Morcha. Look at MC Mehta, various judgments. Look at Godavarman cases, environmental matters, several matters where Supreme Court has interfered and protected the right, liberty and dignity of the individual. And if we just go through all the history, we only see that the Supreme Court and the High Courts have done a great job in our country, unlike in several other jurisdictions abroad. Mind you, I'm not taking any sides, but all that I'm saying is it is very easy to criticize. When you point one finger at someone, the other three fingers point at you. And that is what is happening. All that is coming out is not in good taste. We can reserve all this when we attain normalcy and then speak about it. Friends, I was told that I should be speaking for an hour, and I believe I've just completed 55 minutes or 57 minutes. And I hope whatever I've said is of some benefits to you. I thank you all for participating in this webinar. I also thank Mr. Naveen Kumar Murthy for giving me this opportunity. And it was great talking to you. Thank you so much.
Thank you very much. Sir, thank you very much, sir. Can we just...
Yeah. Yes, Naveen.
Participants can shoot their questions in the chat so that we can probably ask sir regarding the questions. So, do you think that there is an increasing trend that criticizing the government is considered to be neutral, and if anyone sails with the government, as you rightly pointed out regarding the Supreme Court and the migrants matter, today we have had a very detailed order passed by the Supreme Court where a slew of directions have been issued. But people have jumped the gun and they said Supreme Court is not acting, and if we have to give a grading to the Supreme Court, we'll give F grading. Is it become the new normal that if at all they don't attain a desired result against the government, they try to lambast everyone who's trying to be neutral, sir? Yes, sir.
That's what, Naveen, that's a very important thing which you raised. Moment you go to the court, you can't expect that you will get a particular order or particular relief. The government is also required to be heard. And if a decision comes in favor of the petitioner or against the government, see, there is nothing like government losing or winning. Please understand one thing, in one of the district courts in the United States of America, district courts in America, the federal district courts are also the constitutional courts. There was a board there. And you know what that board said? Government wins every case when justice is done to the citizens. See, so nicely it has been put up. So even when the petitioner wins a case, it is a success to the government. But that is the motto of the judicial in a democracy. That if the petitioner gets the relief, then yes, he's right. So the government wins the case. But at the same time, if a citizen comes and says, and tomorrow if the Supreme Court says, look, we'll allow the government some time, let the things cool. The things were such that you can't criticize Supreme Court. And just because you don't get relief and then start criticizing Supreme Court, which is also not a very, it's not a very good trend. This should be somewhere, it requires a very matured introspection, because as I said, I'm not criticizing them or I'm not supporting them. But what I want is each one must introspect that we can't, cut the branch of the tree on which we are sitting. After all, people's faith is there in the Supreme Court of India.
Thank you, sir. So there is one more question that, of course, before the lecture, I got from many participants. Should there be some sort of censorship of social media or some restrictions in social media? Because as sir pointed it out, anything that everyone wants can today go on social media. If it is unverified, verified, it's false news, fake news, anything over a touch of my smartphone button or just a touch in my smartphone, I can publish it, and unverified news becomes a news and it creates chaos. So does sir believe that there has to be some effects of censorship without making it a chilling effect?
Naveen, people who are on Facebook and Twitter, must act as responsible citizens. You can't be a citizen of India and still not be proud of your mother India. Now, as a responsible citizen of this country, you must know, A, not to put out any fake news. 2, not to put out a news in a very casual and irresponsible manner. Now, the question about censorship is a very delicate question. Because if you give the authority of censorship to someone, then he or she will have the power to delete your expression, to delete what you have posted. So censorship requires a larger analysis. Because if you have such a censorship, then you must necessarily provide an appeal against such censorship. You must then create forums whereby people go and can voice their things and get their remedies. But if we all decide to be responsible citizens and not to post any fake news, etc., I think that is good enough.
Thank you, sir. So one more question, of course, following it up with the censorship question. Sir would know that the OTT platforms, Netflix, Amazon Prime, have all become the new normal, and all of us probably were engrossed in the lockdown and movies and web series and all, as the case may be. But recently there was an issue where a web series called Godman, it was deemed to affect the sentiments of Hindus, our religion. And it was completely, the teaser was pulled down, and they said that there is no censorship in the OTT platforms because a movie has a censorship. And if it is an adult movie, there is a parental guidance. If there is a violence in the movie, there is a parental guidance, 13 plus or 18 plus as the case may be. But in OTT platforms, is it required, sir? Would you believe that at least some sort of...
You know, I'm aware of what you're mentioning about. There was a big hue and cry against that particular this one. And to a great extent, there is some merit because a movie is required to have a censor certificate. There's a censor board which is required to censor the contents of the movie. And unless you have a censorship certificate, it is not allowed. But unfortunately, on the websites which you have mentioned, you know, whether it is a pornographic film, whether it is movie creating violent scenes, obscene, everything is allowed on that. Now, our Indian government must come out and say that we will not allow certain things to be viewed. I mean, only those things to be viewed by the adults, certain things to be viewed not by particular section. And surely India is a country which is, you know, multiracial, multilinguist, multi-religious. In such a country of ours, we must ensure that we don't speak something which are going to hurt the sentiments of other people.
Thank you, sir. Thank you very much. So, there is one question that was asked. I think it was in tune with what I asked. I think sir has answered that. I think the participant who has raised the question will be convinced with sir's reply. So just a final question. Sir, do you think social media is now being used as a tool for influencing a neutral person who's apolitical? So there might be people who are pro-left, pro-right. There might be some people who are center. And there are some people who never take a viewpoint. They are just neutral. They just sail with the wind. But by the social media influencing, are they trying to, as it's just a fallout of Cambridge Analytica, are they trying to create a negative opinion, or is social media trying to create something that it should not create? Is sir seeing that as an officer of the state?
I'll tell you, Naveen, it's indeed a good question. I don't know if you remember, in the political science that we studied at that time, we always had something called as pressure groups. In America, they have a very funny thing. For example, even ambulance chasers are allowed. If there's an accident, lawyers can run behind the ambulance, take their wakalatnamas, file their claim, and take a percentage in fees. We never allowed that in India. We don't allow that in India. Similarly, in India, even during elections, etc., we never had this pressure groups and lobbies working. The political parties, they campaign, they advertise, etc., that is fine. This new thing which has come in India, I mean, it's new thing, but it's there for the last decade or so. And certainly the trend which is happening now is trying to influence people, trying to influence a neutral, from taking a particular view, because it happens, it appears. If you remember, in our judicial parlance, there is a concept of trial by newspapers.
Yes.
So it is something similar by that. Instead of the newspapers, you go into the social media. But having said that, I would say that our judges are judicially trained minds who don't get influenced and who should not, for God's sake, get influenced by such what is coming in newspaper or in the media. They should purely go by a matter which is coming up before them, based on the evidence, based on the material produced before them, and go by it. So even if people try to do that, the judicial minds in India are very, very apt, and they are very robust in dealing with these kind of things.
Thank you very much, sir. Sir, thank you, sir. It was indeed a wonderful session. There was just one question raised regarding the Facebook that has planned the oversight committee to check on content. But as sir said, it's something that's self-regulatory. We can't keep influencing. Because even in Madras, there was a matter with regard to the content regulation about Facebook, WhatsApp. It's now transferred to the Supreme Court, as sir would know. But sir, thank you very much. It's a very balanced perspective sir has given us today. Because there are people, if free speech, they take one side or the other. So there is nowhere in between. But sir, as a law officer who's been fair to court, you've been fair to all of us. And you've taken us through the middle way. Thank you very much, sir.
Thank you.
And thank you very much for giving a broad perspective of things.
God bless you all. Stay safe and be healthy. Thank you.
Thank you very much, sir. Thank you very much. Thanks. Thank you very much, participants, for participating. Thank you.